Hello, my name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bong-soo, we will cover a particular case that Gangnam Labor Law Firm has provided the labor law service, which is regarding the workforce harassment and forced resignation. So could you explain the particular story of this case?
Yes. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Today I'd like to introduce a very interesting labor case. So it is related to the Korean branch manager. So he was hired last February. But his act was so harsh and he humiliated his co-workers. Also, he violated company regulation. So many people suffered from his the misbehavior. So finally, some workers they submitted the resignation due to his harsh treatment and workplace harassment. So then the head office of this company they asked not receiving their resignation. So they wanted to investigate this case. So then last October they asked this labor law firm to investigate this case. When we submitted some proposal for this investigation case, then the cost was very high. So they said they investigate those related people by themselves. Then only they want this labor law firm review their the result or some judgment of this case. So we accepted. Then but the HR manager from Singapore had an interview with the related victim workers. But they said, but the nuance in English was not strong enough. Also, the investigation was not based on the when, where, who, what. Is also such a reporting process, reporting method. So it was not professional. So, but based on those documents, company asked for the voluntary resignation. Then the company suggested we'll pay maybe 2 months or 3 months additional salary if you submit the resignation letter. Then the Korean branch manager rejected. He said he didn't harass the people. He didn't violate company regulation. So then this HR team asked this labor law firm how to handle this case. So I explained to them. So in order to have him to submit his resignation is based on actual fact. How much he severely violated company regulation, how much severely he harassed his workers. So in order to define or in order to understand the actual case, you have to have a Korean investigator to investigate this case. Without that, you cannot ask him to accept the resignation. So they decide to hire this labor law firm, and we send 2 labor attorneys, and we had a job interview with we had an interview with 10 the victim workers and some witnesses. Then the case was very severe. So based on those investigation document, we had an interview with the offender, like this Korean branch manager. So she was so surprised to know how he handled. So his action was unilateral, but he didn't thought his action was such a violation case. So he little bit changed his mind. Then he suggested he'll accept this resignation if company pay 9 months additional salary. So then company could not accept. So then the company had some disciplinary action committee, and company decided to dismiss this Korean branch manager. So after we company dismiss this employee, then we send some message together. If you are now dismissed, but if you accept 3 months additional pay, then we'll consider it's a peaceful resignation. So he accepted. So I think so we successfully terminated his employment contract. So when we look back on this case, we could learn something good lesson. So in order to suggest some forced resignation, we must have a tangible evidence. Then usually the target employee may accept this company's suggested the resignation. Without that, usually employee never accept this resignation. Yeah.
I see. So, as under the Korean Labor Standard Act, it's almost difficult for the company to dismiss a staff. But in such case, because he was guilty for workforce harassment and like bullying to the other staff, and since the Gangnam Labor Law Firm has made a fact finding about the what cases that he committed, that's why he finally accepted the resignation. Is that right?
Yes, right. Yeah. In Korea, dismissal is very strict. It's hard to dismiss an employee. However, the Article 23 it said without justified reason, company cannot dismiss employee. But if there is justified reason, then company can legally dismiss employee. So it is important to have a justified reason for termination. So that's why we had a very thorough investigation process regarding this case. Yeah.
I see. And in order to find to prepare the report of all this staff, it must have been taken a long time to finally make the final report and submit to the company, to our client. Is that right?
Yeah, that's good advice. Yeah, really. So, I like to suggest to companies, first resignation is not easy, but you have to prepare some certain document that verify the reason of termination. Then usually it is very strict. The reason is so acceptable. Usually, target employee accept the company's suggestion. Yeah.
I see. So, in such case, in case of when we compare this with the country like U.S., if this kind of employee or manager make some workforce harassment, maybe he should have been forcibly kicked out of the company, but because of the Korean labor law does not allow that, then the company had to still pay 3 months of additional salary to make him sign the forced resignation.
Yeah.
Right?
So this is we call it settlement process. So it is required or suggested. So without that, even though we are strong in this case, if we go to the labor commission, then the company should hire labor attorney. Also, they may have a hard time through 3 months. So it's better to pay some small amount of money to get a good settlement rather than just immediately dismiss employee. Yeah.
I see. Thank you very much for introducing the case.
Okay, thank you. Thank you for your watching. Bye bye.